He's like, don't like that it's not uniform, and I was like, I know, we don't care. We just want to
All right.
That's hilarious.
Okay, everybody, let's get started.
Don't forget
Nantucket.
to use your mic as much as possible. Just really chew on it.
Hello, hello, hello. Okay. Let's start the Nantucket Conservation Commission meeting for Monday, May 20th. We are recording, so if you are recording, excuse me. We are recording, so if you're recording, please let us know. And if you could silence your cell phones, that'd be great. We'll start with the public meeting, public comment for items not being heard tonight. Seeing not, very good. We're going to go into the public hearing, notice of intent. Starting with the Sconset Beach Preservation Fund, 59119 Baxter Road.
Real quickly, well, Stephen's coming up. If you come up to provide comment, please get as humanly close to one of the microphones as you can. We get a lot of feedback that recordings of this are very hard to hear, people with comments and board members, so just make sure you get close enough where you feel like it's being picked up and you can kind of hear yourself back a little bit, so it makes it onto the stream.
Okay, so as you well know, I'm Stephen Cohen. I represent the Sconset Beach Preservation Fund, Inc., and all of the abutters, including the town of Nantucket, that have filed the notice of intent for the extension of the erosion control CES that currently exists from about 500 feet to almost 4,000 feet. What we have filed in the past, since our last meeting, is four things. There were two documents, one that responded to points that were made at the meeting and one that responded to points that were made in subsequent filings by interested parties. And frankly, I would call those the asked and answered memos 1 and asked and answered memo 2. We're not going to go through them. We're happy to address any points in them, but frankly, I think they're a really useful exercise, because if you've had the same questions, if you could flip through them and say, well, what's the exact answer to that question? So I think it was a useful exercise, but I don't know if it's a useful exercise for me to repeat it. If you went through it and didn't find that you want me to talk about it, I won't. The other thing that we have is, in the last meeting, Town Council Attorney Cucci raised some questions about the legal standards under the state and local bylaw, and also the issue of gap lots, and we have a memo about that. And I'll let Glenn Wood talk more about that, but needless to say, we take the position that legally we're on solid ground. And then the last thing that we have submitted is a filing that shows the distance of all of the houses or lots to either the lot to the road, or from the edge of the bluff, either to the nearest structure or to the edge of the road if it's a vacant lot, because there's some question about those distances. And also, in going through that exercise, have made the determination to shave 117 and 119 from the project. Those are both vacant lots at the northern end of the project. Now, it used to be that 117 and 119 were both covered, and then the return extended onto 122, which is the next lot, I think, in that row. We have scaled it back so that 117 and 119 don't have any geotube in front of them, although 117 contains the return. So it's still in front of 117, but instead of being direct geotube, it's the return. And those are basically scaled so that you have sufficient protection past the last structure at 115 Baxter Road in order to provide protection. So without going through everything that we've done, we think that the project in front of you is a very good exercise in lessons learned and information collected. That there was a requirement to collect a substantial amount of information, and what we have determined is that some of that information was not as specific as it should have been, and we now want to collect it. Other slightly different information, some of it was overkill, and we maybe don't need it as often, or in some cases at all. And other information is better if it's collected at different times. So without going through it point by point, we think we've done an assessment of the data collection and that we've got it refined to a way that makes it more useful, including collection of information that the public has pointed out wasn't previously required that would be useful. We think that the design of the project is now better both in its ability to provide protection and also in its ability in its lessening any negative impacts. With the mitigation is much better that we have now. We think that the adaptive approach is going to be a highly beneficial way of addressing this, both in terms of making sure that there's more sand available, that there's less time where it's uncovered, that there's less construction activity, basically good all around. Our ability to address any of the negatives that were observed is highly emphasized by this project to the maximum extent possible. And we've also adjusted the returns to have shallower, longer angles to avoid problems with erosion, with scour on the ends. So we think that the design, the mitigation, and the information collection is the best that we could possibly do, and the most appropriate for this particular location. And we think that the legal standard is well justified, and the facts and the law justify the project as proposed. So it's our intent today to close the public hearing and move into the order of conditions session. But I'll just let Dwight and Glenn briefly address the two issues that they've submitted. Thank you.
Thank you, Stephen. If you don't mind, I'll sit down just so that I can operate the laptop a little bit easier. And the microphone. But as Stephen mentioned, we have addressed responses to comments. Frankly, we've gotten to a point in this process where the comments are being repeated. I'm not going to go into the responses, but just to identify the issues that have been addressed in the most recent submittals. That the existing GO2 project was meant to be temporary. That's been responded to. Alternative access to Baxter Road, that's been addressed in previous hearings. The number of days the geotubes have been uncovered remains unknown. The SPPF complies with the conditions of notifying when tubes are exposed and what the process is and the schedule to get those recovered. The number of days the walkable beach has been maintained. We've addressed that. Rate of erosion has continued to be a discussion. We've addressed that numerous times. Just going through here, the public beach narrowing, the most recent data does show that there's been a modest accretion in front of the existing GO2 project. That's been addressed. That the GO2 structure will occupy coastal beach. We've addressed that, and that's allowed under the state regs in 1027. The end scour will continue, and as has been discussed, there is end scour with these types of projects. It's been addressed that the idea here is to manage it and maintain it, as opposed to just not managing anything at all. And as you know, the protocols that are proposed, the protocols that are in place for the existing have ongoing maintenance and management. In terms of the beach being construction site, that's been addressed. It's pretty much all the work is done in the late fall and winter months. Alternatives, the last 20 years or so have been a continual alternatives analysis for this project, going back to Coir envelopes, terraces on the bank, which proved not to be effective, to beach dewatering, to beach, which proved not to be effective, to beach nourishment, which was denied. So there's been an ongoing alternatives that have been pursued in practice and in theory here over the last 20 years. That's been addressed. We've addressed the performance standards throughout the process, including the eligibility of homes. The waiver request is presented in the notice of intent. In terms of sand sediment source, that we've addressed that at the previous hearings. The gap lots we've addressed in writing, and Glenn will also discuss that briefly in terms of the legal aspects. And then we get into, again, erosion rates and sand contributions. Large projects, as we've noted, the wetlands protection regs and the bylaw regs can scale up or down to accommodate projects of any size. And this project is proposed to provide protection to all the homes within this project area. So just wanted to just go over the topics that have been covered. And this is a little different format. So as Stephen mentioned, what we have here, just wanted to go over quickly this is the proposed site plan that was provided to the Conservation Commission. What we've shown here is the reduction in length to protect the homes, the northerly homes of 115, 113, 109. We have the vacant lots of 107, 107A, and the existing project that extends on to 105. The shallow returns that we've accommodated in the design when we take that and extend it for the south, and the revised extensions for the existing project to the north then would make an actual physical gap even smaller than the length we've identified in writing of about 300 feet. Likewise, for the southerly segment of the project, we have the existing returns, the returns that would extend in a shallow angle from 83 northward to protect 83, again, reduces the actual gap across the vacant lot of 85 to be less than the gap identified in our written responses. And again, just to talk about why this project is being proposed, these figures 1 through 4 have been previously submitted to the commission. You know, at the northerly extent, we have houses that are close to the top of the coastal bank, with very short setbacks between the house and the top of the bank. And what does that mean? You know, we look at this aerial, but when we look down at it, we look at how close these houses are. Pretty much all of the homes, as we documented, have been moved to the landward, as close to the street as possible. Pretty much all the homes have been moved already away from the coastal bank. So we are looking at homes that are, you know, in danger from continued erosion of the coastal bank. As we continue down, you know, this is the existing GO2 project extending onto 105 and then down beyond 87. That's in place. We continue further south to the northerly end of the proposed project, and what we're seeing on the bank is exposed steep bank with rill erosion, showing that this is actively eroding. And we also, when you see these signatures here, this is actually where you're having slope failure. It's yes, the slope is vegetated, but the slope is failing. So we see slope failure, and these have the setbacks to the homes. And we continue further to the most southerly end. Again, we have some pretty short setbacks, and we continue to see this slope failure. I'm just going this back for, you know, what's the project purpose and need here? The project purpose and need is to provide a bank stabilization project because the existing coastal bank, we have, you know, this is an example here at 67 where we have the top of bank scarp, the mid slope is eroding, again, exposed substrate, no vegetation, rill erosion. Further down at 65, these are behind the existing Coyer system, but the water continues to overwash those areas, causing slope failure and erosion behind them with the scarp. And down by 63 and 65, we see the same type of situation. Again, down to 63, 61, we get that slope failure. So this is what we're looking at. It's one thing to be looking at aerials, to be looking at plans that show contours, but I just wanted to identify what the project purpose and need is throughout the process in terms of making a permitting decision. As we've mentioned, there's been 20 years of projects out here which provide the baseline for an alternatives analysis. We've reviewed the compliance with the performance standards for both the state and the local bylaw performance standards. We provided a robust mitigation protocol with the adaptive management being, filling it to 22 cubic yards per linear foot before having it filled to that volume before each storm season. And then based on the annual reviews of the volume of sand lost off the template, backfilling the template to that 22 cubic yards per linear foot before the following storm season, or as we mentioned verbally in one of the hearings, having a minimum of the 8.8 or what was documented to be lost, whichever is greater, so that we are making sure there's plenty of sand available on the template, basically the on-site sand stockpile to be reused to recover exposed geotubes after erosion events. This topic of erosion events, sand mitigation, has been going on for this reach of bluff for many years, back the 03-04 time frame for the Coyer terraces. There was a discussion, and at that time a volume was identified by John Ramsey which came out to be about 20,000 cubic yards for 22 linear feet, or 20, it works out to be about 10 cubic yards per linear foot per year was identified as an adequate volume of sand to protect downdrift landforms. What's proposed here is double that, which 22 cubic yards per linear foot available each year, and that is about 2.5 times what the average erosion rate is for the length weighted average here. So with that, we've just wanted to kind of go through the purpose, need, and how the project has met all the standards for a permitting decision to be made. Thank you.
Can I just ask a question? Was this document shared with us?
The revised plans were submitted to the Conservation Commission last week.
Well, this was some of the measurements of the homes to the bluffs.
That was provided in the letter submitted to the Commission in November.
Hi, Glenwood, Rubin and Rubin, Regulatory Counsel for SPPF, and Dwight is correct. Those numbers show the imminent risks that exist to obviously many of these properties within the Phase 2 area. I was asked, based on the discussion at the last CONCOM hearing, to look at the whole concept of gap lots and see how the Commission reviewed it in the past and see what there might be out there in terms of other precedent overall. As you know, I do a ton of this stuff, and I started scratching my head to think about what was out there, because I couldn't come up with much. I knew that there was something out and way past in the history in New Seabury, who I used to represent a long time ago. And I dealt with a few gap projects here and there. The reality is that there just aren't that many of them. They just don't come up that often. And I think the reason why, in retrospect, after looking and finding there's no adjudicatory decisions, there's no decisions in Massachusetts case law under local wetlands bylaws. There's just nothing. Is that they really just don't come up that often. And I started thinking, well, why is that? And the reality is that it's because revetments, which is really the vast majority of CESs. I mean, back when Ratner was doing his geotubes, which I permitted, those were not deemed to be CESs by DEP, or even, I guess it was DEP. I mean, so there's been an evolution in a hardening of the definition, and correctly so. I don't disagree with it, because I mean, Ratner's, was a CES. I mean, he was getting new. We all know what that became, right? Among others, Warner, who I also represented, and Sheep Pond, and so really, I mean, CES is really, in the end, are revetments in the vast majority of fact patterns. And the reality is that there aren't that many long, linear CES installations. There just aren't. There's a lot of them that are hodgepodgey and lot by lot by lot. Like if you look at the bay side of Eastham, you see that the vast majority of houses are revetted. Because most of them are pre-78. And you also see at New Seabury, for instance, a vast majority of properties, many of which are not owned by New Seabury, but owned by different other legal entities, are revetted. But that was a longer linear project, so there wasn't any gaps. Interestingly, the one historic one that we did identify, with the assistance of Jim Mahala at DEP, who's been doing all of these and reviewing all of these for the Lakeville office for 35 years. He's now the section chief. I mean, I cut my teeth with him starting 35 years ago. There just aren't that many gap projects, and you're becoming the experts in gap projects, it would appear, including within your OOC, respectfully. And I think that's where it really comes to. And so the few that we found were situations where a conservation commission, or in the case of the New Seabury one in Mashpee that we point out, both in the Epsilon submittal and my submittal, where you have a narrow gap between pre-78 properties, and the one in Mashpee, you had pre-78 properties to either side. The one in Mashpee, there's two house lots that had no houses on them. And DEQ at the time, in fact, 30 years ago now, exactly, approved that on appeal and allowed a revetment to gap over two parcels that were interestingly, subsequently both developed on with houses and have, their own houses on them now. But in the justification for the gap project and in that approval by DEP Lakeville, by Jim Mahala at the time, the finding was that it was to protect the adjacent properties on either side. So that is one of the few classic gap projects that actually does exist. There just aren't that many. And I can tell you that both Epsilon and myself reached out to every consultant that we work with to try to see if they had found any. One other one that we found through Woods Hole Group was the second one I speak to in my letter, which was in Hull. And again, it protected just one lot where there was a gap between existing hard structures, historic hard structures on Spinnaker Island, and it was just approved at the local level in February of this year. And the only other one that we found, again in Eastham, which is sort of like ground zero for residential revetments, because it just gets hammered with northwesterly storms in the winter. And so everybody is pretty much pre-78. I just got one permitted recently. The Concom denied it because my client had a pre-78 house, but then they put a new house on it. And the Concom said, well, the house that's on the property isn't a pre-78 house. And I said, well, that's not the way the DEP interprets it. The question is, was there a house on the property at that date in 78? And even if you rebuild it, if it's torn down, if it's burnt down or whatever, in this case, they actually built the house, the new house, even a bit closer to the top of Coastal Bank. The Concom denied it, DEP issued SOC, the Concom didn't take an adjudicatory, and we settled the Superior Court appeal, and it's installed. So there really just aren't that many gap projects that do exist out here. And I think that the lessons learned from the project as approved by the commission gives as much guidance as to how the gap projects or the lots to protect public infrastructure under the local bylaw can be approved presently for the Phase 2 project, both on the northern side with the proposal we're talking about for Lot 107 and 107A, and then on the southern side with the lots that Dwight also identified. I think that the commission properly found in your Phase 1 OOC that there was justification both as gap projects under the Wetlands Protection Act to protect pre-existing properties to either side, which is the purpose and how these have been looked at in the limited ways that they have been looked at, and also under the bylaw to protect pre-78 properties or building structures. I'm sorry, you have a broader definition. The Wetlands Protection Act reg talks about buildings. You protect structures, which includes like patios, and it's a broader term. I think it makes some sense. Or to protect public infrastructure. So we think that when you bundle, and I think it's a bundling concept here, when you bundle these together, there surely is more than enough justification legally and regulatorily under the Act and the bylaw, both and some limited precedent in the past, and surely your order of conditions. I can say in doing this kind of work, and I do it every day of the week and I've done it forever, DEP Lakeville, whenever they get an NOI for CES, a red flag goes off immediately. They watch what a commission does on every one of them, and they watch them closely. And on those rare instances like the Plymouth case, which we identified, which they appealed up in the recent past, and they denied it, and then there was a settlement, they found that the gap was too wide and that a CES wasn't justified in that situation, and a non-CES could be put into that longer linear space between revetments to either side. But as opposed to the applied, I think it was applied full submitted comment and the recent submittals that just because DEP hasn't appealed something to themselves doesn't deal with reality. The reality is that Jim Mahala, who's been the head or been in Lakeville forever, and his staff looks at CES filings extremely closely, every one of them, and follows them. And if they have a problem with it, they're going to appeal it to themselves. And they do that on occasion. This is not an infrequent situation. And I will say, it's my professional opinion, that if the department had a serious problem with your Phase 1 OOC, they would have appealed it to themselves. And so therefore, I believe, legally and regulatorily, they deemed that what you did with your Phase 1 approval was justified under the Wetlands Protection Act, and they didn't appeal it to themselves. And I'm entirely confident that if the commission were to choose to approve Phase 2 in a similar fashion to Phase 1, DEP will not appeal it to themselves because they'll feel that you've done the job that you should do here. So that's sort of my oversight of these. I don't have much to offer here, but I think that the nuggets that are out there are genuine, in addition to all the hard work that you've done with your Phase 1 review and approval of it and all the monitoring of it and everything that's gone with it. Thank you. Appreciate it. It's been a long hearing.
Questions from the commission?
I've asked all my questions.
Yeah.
Whether or not they've been answered is another story, but they've been asked.
Same as myself. I will repeat the comment, though, that when we were talking about DEP approving the last application, there was discussion in the last meeting about how the protection of the road was, in their paper, was a temporary, even though it was a bunch of gap lots, they were protecting the infrastructure of the road temporarily until the alternative route. I'm curious what your take on that is, since you weren't here at the last.
The SOC that they issued, or?
Well, they basically were saying that for protecting the vacant lots that on the closest to the road,
Right.
for what exists now, it was a temporary. Granted, they were expecting a new application for expansion of the project, but at the same time, their letter is pretty clear to state that they didn't feel that area in the middle was. We don't get the feeling, many of the members of the board, that it was considered a permanent. The section existing now was going to be considered a permanent.
Well, I guess my view is what's permanent anyways, and what do we think they were even suggesting permanent even means? I mean, do any of us think that this is a permanent solution?
Well, I think that, no, my point being that they were expecting the alternative access, and this would be for temporary until the alternative access.
I don't read that into that decision whatsoever. I think that's a misreading of of their wording.
I don't mean to beat a dead horse here, but I mean,
Well,
yeah.
the decision definitely.
Yeah, you probably should come up to the microphone. Sorry about that. I mean, I don't want to keep repeating this one. It's just, you know.
Right.
I mean, DEP definitely gave direction that the idea of mitigating the imminent danger should be addressed by at least looking to see whether or not there could be relocation. And so, DEP didn't have the time or information to make that decision, and they punted on that. They said, you guys should definitely go back and look at that. And we did hard. And we looked at, could the road be relocated? Could the utilities be relocated? And what would be gained in doing so? And there's an alternative access agreement that says that if there's a breach at the northern end of Baxter Road, that you would create a path that would come in just to allow for access. It wouldn't, allow for, essentially a road on the other side of the house, but just to connect those points, so that you wouldn't have people who were cut off. And I don't know if landlocked is the right term, but sort of the opposite of landlocked, where they have no access. But the order of conditions that you issued under the NOI provides for this protection of these lots. And really, I think what we need to do is look at what we're applying for here. And what we're applying for here is a protection of the pre-78 houses, and the protection that is proposed both protects those houses and has extensions that deal with the necessary protection around them. And in some cases, there are vacant lots, and we looked at it. If you take these returns and put them, one on one side and one on the other, and you end up with a 50 or 60 foot soft spot in the middle, does that make any sense? Or are you essentially creating a washing machine in between two returns, so that you've actually made it worse than having a straight line of coastal engineering structure? And in each case, we came to have that determination. But in this particular case, that having gaps with soft structure didn't make sense. And I'll tell you, the opposite of that is that in Dionys, between the Tolkien and the Gun properties, there are two rock revetments up there, and there's something like 600 or 800 feet in between them, and they really wanted to come in and run the rock away. And you properly found that that's too much of a gap in between, and you require them to put arrays in there. It's also a different marine environment, so that, but there was no pre-78 house in there. But in this case, we think that the existing structures and the project as a whole justifies what's proposed. I think if we were coming in to try and protect, one lot at a time, it might be a little different. But because we're looking at this comprehensively, it's what makes sense.
Sure.
I'd just like to point out two things in addition to what Stephen mentioned. One is the SOC and the order also identified that future submission of a future request for the extension. I mean, you all know that the original thing was a 4,000 foot rock revetment that, through all the processes ended up with this initial plus or minus 1,000 feet, and that it was contemplated that this would be submitted for the longer project with 3 to 6 years there to do the engineering, the permitting, and all that. So I just wanted to bring that up because it hadn't been brought up yet. The other thing which we have in the written record, in terms of the ability to approve this project, the extension of the CO2 system under the state and the bylaw. Under the state regulations, all of these homes are pre-78 homes, so they're all eligible for protection by a CES. As we talked about, the gap lots that are connecting the existing CO2 system to the proposed length. And as Stephen mentioned, when you add the return to the north, return to the south, you might get a very small gap that actually exacerbates the problem rather than fixing the problem. Also, pragmatically, it would then have a break in terms of trying to maintain the GO2, the template, as required under the existing order, and we expect similar conditions to be in an order should the commission issue an order allowing this to go forward. So that those are needed pragmatically to maintain the GO2, the SAM template. Under local bylaw, as you all know, we've had discussions about the eligibility. Our opinion is all but 2 of the homes are locally eligible as pre-78 homes. The vacant lots then are eligible for protection for the infrastructure. That leaves the 2 lots that we have agreement on in terms of being replacement projects, being short lots, 81 and 69, such that again, when you have extensions to the north and south, ends up that means you have an extension that basically coming tangent with each other. So that's why this extension project is eligible for protection and permitting under the both of the applicable laws.
Thank you. Okay. So if there's no other questions, I will open up to the public, but only new information, stuff we have not heard, would be appreciated. Do we have any questions? Please.
Thank you, Mr. Chairman and Commission. Emily Molden for the Nantucket Land Council. I submitted an additional letter to the file last week, and I will just let that stand on its own for the Commission. Again, I thank you for your time. Just a couple of final comments. We have heard the applicants state and restate that they are in compliance with all the performance standards for the project as it's proposed. We contest that there are still a number of state and local performance standards that they have not demonstrated compliance with, and leave it in your hands as you deliberate to identify those. We've raised them in the record previously. And also don't believe that they meet the requirements for waivers to those performance standards. The only additional issue that I just wanted to bring up based on the submission of the new plans, something that has been discussed in the past, just not recently, to bring your attention back to, is in your deliberations, if you're moving forward with an order of conditions, the southern extent of the expansion and the presence of the coastal dune. And we've heard it documented or stated by the applicants that that coastal dune has been eroding at this point, but prior to the installation of any structures there, I think it would be important for the commission to require a coastal geologist or of some sort to go out and just document for sure and confirm that there's not a coastal dune in that location if a structure was going to be permitted there, and just to further confirm that resource delineation. And then our consultants, Applied Coastal Research and Engineering, also submitted a letter, and I would just ask Trey to come up and address a few final issues with you. Thank you.
Hello, I like the seating thing. So Trey Ruthven for Applied Coastal. I just wanted to cover a few things and not kind of beat a dead horse. But for clarification, the beach nourishment project was never actually turned down; it was withdrawn, which is kind of important. So talking about gap lots, you know, we're hearing about why we're not seeing many case laws, and my take being on the other side is that I would think most coastal engineers or people that are eroding projects are looking at, you know, what's in front of them and what's permittable. I mean, why are we going to start applying for projects that are non-permittable? You're basically taking money and you're wasting it for a client. So I think the reason you're not seeing a lot of these projects with gap lots is they're not permittable. I mean, why am I going to go through with a project that I can't get permitted? I spent some time talking with DEP and Jim Hall also, right before Les did, to talk about, what was going on when this initiative was approved. And Jim was frank. He said, it was a deep deliberation, and the reason the initial project was approved was to give the town time to relocate that road, to figure out what to do, because a 30-day time window is just not applicable for figuring out that solution. He also thought it was interesting that no one appealed it because of the gap lots. He said, we were on weak ground. So I think that says a lot. We've obviously seen DEP in Plymouth right now saying, that's not permissible. And we talk about, well, we have these returns extending onto lots next door. There's nothing in the regulations that actually directly permit those returns extending on the neighboring lots. Those returns could be actually contained within the lot. They're part of the coastal engineering structure. So when we start extending beyond those lots, we're actually starting to put structures in front of properties that are not afford that protection. I mean, obviously, if you had a house that was post 78 and your neighbor wants to extend the returns there, it benefits you, but that doesn't mean it's actually permissible. So, and the one thing, I don't want to beat a dead horse, but I was looking through the email I got last week from the Epsilon, and in the plans, I noticed a few things that I thought was pretty interesting that I just wanted to point out. If you look at the cross sections that they provided, you'll see that they show the 2007 and the 2008 LiDAR surveys. The one thing I found interesting is that the coastal engineering structure here is offset from the existing coastal bank anywhere from 20 to 30 feet, which means it's seaward. It's actually close to the beach. Now, if we look at the regulation that they're using to actually approve this, which is the coastal bank regulation, the one thing it actually requires is that the coastal engineering structure or modification thereto shall be designed and constructed to minimize, using best available measures, adverse impacts on adjacent or nearby coastal beaches due to changes in wave action. By extending the structure out further, instead of actually sitting on the natural bank, we're actually increasing reflections. I mean, the previous structure, we were able to build it on the bank. Now we're actually grabbing land seaward and pushing the structure further out the beach, which I think directly goes against what that regulation says. If we were going to actually build it to the reg, we would be pulling the structure back as landward as possible. That's what we see on all these structures. We're not allowed to extend outwards. Another thing I thought was interesting is that if you look at those erosion numbers there and how far it's set back in 1 year, that's anywhere from 20 to 30 feet. So when we talk about erosion numbers and they say, we're not eroding quicker, that's 20 to 30 feet. Those are the numbers we're starting to see when I'm actually using their data. Once again, in my memo that I sent, they said, we're not having any further erosion. I plotted the data from the new monitoring report that came out. And once again, we're seeing continuously on an annual basis that we are eroding quicker with the structure in place than we have in the past. So that just goes to show that, if we're going to approve this project, you need to take a serious look at mitigation. We basically dropped it by a third from 22 cubic yards, and erosion is actually increasing. That goes to show that, we're going to have an adverse impact. We're not just keeping the status quo, we're actually making it worse. We're not actually mitigating what we have to. And we're also not meeting the regulations. So thank you. Good luck.
Good afternoon. I'm Dirk Roggenay, and I represent the Quidnet-Squam Association, which are property owners to the north of this project who are facing the prospects of increased erosion if this project doesn't work as it's actually been represented that it would work. And in order to do that, the big concerns are that if this project is permitted, let me back up. This project probably shouldn't be permitted because of the overall impact it's going to have. But we obviously know the history that DEP allowed parts of this project to go in essentially permanently to protect pre-78 houses. And if the commission's going to go that direction again, then the concern of the neighbors to the north in terms of the impact it might have is that it have sufficient mitigation, which we've obviously people have argued about and Trey just spoke to, and that it not be built larger than it needs to be built. And I gave you all copies of this last time. I'm the attorney representing, Mr. Woods representing Sconset Beach, has, I think, interpreted this not to mean what it actually means. I mean, part of it is, it says what it says. You can read it yourself and not try to reinterpret it. But the letter that came with that superseding order of conditions from Elizabeth Cole-Harris, who is the chief of the program, Wetland and Waterways program, actually explains what this means in a little bit more of an expansion. And again, this is in the record, so I would go look for it. It's on page 2, paragraph 3, and it sets out that temporarily you can have this here. You can have it permanently in front of the pre-78 houses, but you can only have it temporarily here. We'll let it be there for 3 years while you relocate the road. There's one other issue when you think about this. If you permit coastal engineering structure in front of properties without houses, without pre-78 qualifying houses in front of them, then you're setting up a precedent that you're going to be facing again in the future, because people will come in here. This is Nantucket. People have lots. They don't want, they may not be qualifying, but they're going to come in and say, well, you let Sconset Beach Preservation Fund do it. So we should get it too. And you're going to start being in a situation where you're constantly trying to defend a decision and differentiate Sconsets from what's facing you. And you have to go through a whole lot of convoluted arguments, actually, I think, to justify putting these in front of the vacant lots or the non-qualifying lots. I would suggest that you use the basic understanding of the law, deny something like this, and let DEP, if it wants to override you, let it make the convoluted arguments in favor of overriding you and allowing this to go forward, rather than you doing that, because I don't think you want to face as a precedent in the future. You'll have DEP's precedent. You'll have to deal with what they say, but I don't think you guys need to do their work. Okay.
Okay. Excuse me. Other questions? New information? New information?
Mr. Chairman. Deanne Atherton, Nantucket Coastal Conservancy. We made our final comments at the last hearing and just want to have, just finish up a couple of loose ends. One is we want to draw your attention to the written opinion that Town Council sent to Attorney Cohen that points out to you that the alternative access at Northern Baxter Road is not predicated upon permitting of this project, as you have been told several times during the course of the hearing. And this letter to Attorney Cohen is now posted on the town website on the Baxter Road filing information page.
What's the date of that, Diane?
The date of this is April 25th. So we want to make sure that that's in the record. Another document that we'd like to insert into the record of these proceedings is the settlement agreement that was reached by the parties in 2015. And the reason we think it's relevant for this record is the final clause, which is highlighted. And I'm sure you're familiar with the provisions of the agreement, but the final clause I think is particularly relevant given some of the information that's been submitted to you recently, talking about consistency of your decision, that you permitted the 900 feet, and it would be inconsistent for you to not permit this expansion. The last clause in the settlement agreement, to which all the parties concurred, was, this recommendation is made in light of a vote by the Concom to settle the litigation along these terms. However, it is recognized that there are no precedents, no preconditions, or expectations for any future Concom actions. So to say that something was done in 2005 permitting the 900 feet, according to this agreement, should not have any bearing on the decision that you make now. We also wanted to make sure that the November 5th, 2013 letter from Dr. Young is in the record of these proceedings, and we will make that clear with Jeff and Joanne, and mostly because that contains the basic science in the record and the following statement, that when placed on an eroding or retreating beach or bluff, geotubes will cause that beach to narrow and eventually disappear. The other thing we wanted to point it out is that we had asked at a previous hearing, I think it was 2 hearings ago, what is the applicant's life expectancy for this project? Is it 10 years? Is it 20 years? Is it 30 years? And we'd like that to be entered into the record. And we've had no response from that. And then finally, if the hearing is closed this afternoon, we just want to understand the process going forward so that we're all clear on that. And it's our understanding, we think, that once the public hearing is closed, that all information from the applicant or any of the applicant's representatives will go through the administrator and not one-on-one with any commissioner. Is that the process?
So once the public hearing is closed, we don't accept any further information from any party to enter into the record. So anything that someone submits would go to the office and would simply be held. I mean, it's pretty common practice for any of our public hearings. So if anyone submitted a comment letter after the public hearing was closed, it wouldn't make it into the official record.
Okay, thank you. I'm talking more about personal communications one-on-one that will go through you. We're concerned, maybe George, I don't know. We are just concerned because in the past, we understand that there were communications between the applicant and individual commissioners outside of the hearing. And we just want to make sure that that's not going to happen again in the spirit of full disclosure and transparency. We're not suggesting that it will. We just want to make sure that it won't.
Can you hear me from here, or do I have to come up?
I think you have to come up.
Yeah,
we have to
Thank you.
Good evening, afternoon. Members of the Commission, George Pucci from KP Law Town Council's office. Excuse the lack of a suit. I've had a long day down in Nantucket today. A lot of other matters before this one, including a couple of site visits. But so in answer to that question, number one, I just want to clarify, I'm not, by answering that question, I'm not confirming if there's been any communications with any particular member before. I don't know if that's the case. One thing I can say, though, about that question would be there really is nothing which would legally preclude an individual member from having a conversation with someone. However, this is a quasi-adjudicatory hearing process before you, that you're rendering a decision based on a finite compilation of material that's before you. So I would recommend against having any type of communication with the applicant or project opponent, for that matter. Any communication outside of the public hearing process would be a very disfavored approach, because it, again, you're acting like a quasi-judicial board on this, and it calls into question about ex parte communications that you would maybe, be improperly influenced. So I can say, in terms of a
without knowing what may or may not have happened before in terms of such communications, I would recommend strongly with respect to this process that individual commission members not discuss this matter in any way, shape, or form outside of the public deliberations that you would have in a public, publicly noticed open meeting.
Thanks.
No, I don't think so.
So, I think with this project, it's easy to cherry pick little pieces and point here and there and say, what about this, what about that? And it's easy to argue the numbers, and sometimes one side is right and one side is wrong, and sometimes maybe they're both right or they're both different, or it's easy to just sort of spin around forever about this. But I think at the end of the day, what we have proposed shows that there's a sufficient number of pre-78 structures, that they are in sufficient danger, that this coastal engineering structure is justified under the local and state bylaw, and that the proposal is done to the best design possible, both in terms of its engineering and its mitigation and its data collection, and particularly with respect to the failure triggers and protections that are in place in case anything happens in the future. So I would encourage you to approve the proposal before you and request that you close the public hearing. Thank you.
Is there any more questions from the public?
Well, I suppose, can we ask town council questions after the hearing is closed?
Do you want to take that one too, George?
Yeah, you could, yes. You could request legal opinions or anything like that. I just wouldn't be able to submit additional substantive information to, in support or against the application.
Yes. So George, unless I'm misrepresenting Mr. Wood, didn't you refer to a decision where a pre-78 house was demolished, a new house was built in its place, and it was afforded pre-78 protection?
Yes, I was in Eastham.
In Eastham.
Pre-78 house, torn down, rebuilt. And the question just is, was there a building on the property pre-78?
Do you know if it was built in the same footprint, or?
I said it was built actually closer to the coastal bank.
Thank you.
And DEP issued an SOC, and then they settled under the bylaw, and it's been built.
So I guess I would ask if you wanted to address that in terms of our local regulations and the details I submitted earlier, where houses had had more than 20% added under our local bylaw, it would preclude them from having pre-78 protection.
Yeah, if your local bylaw were more restrictive, you could apply that and deny it under the local bylaw. It would be a different appeal process. If you denied it under the bylaw, it would be a appeal to the Superior Court. If it was an appeal of a decision under the state regs, that would be an appeal for a superseding order to DEP. You do want to be careful about that other lot that Glenn referred to. Would make sure it's in your record if you want to address that. If you do want to look at that, if you find it analogous, or you want to look at it factually to see if it's analogous, you're free to do that. But you can't. It would have to be information in the record. So that would be pretty much all I have to say about that. One thing I did note before, I do have a concern that about your bylaw regulation being less restrictive than the State Wetlands Protection Act regulations.
Right.
And I would, in that instance, I would recommend applying only the more stringent standard.
Right. Thank you.
And I should say as well, one thing that you didn't ask, but I would point out, the state reg is different than your regulations in that it does allow reconstruction of the pre-78 building.
So, actually, I'm curious, with that house in East Hampton, was the house previously there when the revetment was made? Was the house, original house there when the
project is analogous to
No, it's more of a
because
curiosity.
basically it wouldn't be permittable under your bylaw because it was total new construction, so to be over the 20%. So it wouldn't be deemed to be grandfathered, quote unquote, under the bylaw. So it wouldn't be analogous. I'm not using it. It's not in the record, and I'm not suggesting it helps us in any way. It doesn't. It was permittable under the act.
Right.
It wouldn't have been permittable without waiver under your bylaw. So I think you're right on that. So.
Well, it's always interesting to hear you talk, Len. So, always informative.
Wow.
I love our moments together again.
We can end on an agreement.
How about you?
There you go. Okay. Well, if there's no other questions, and we have everything we need,
Yeah, unless you guys have any other outstanding issues or concerns, we'll make sure everyone's got everything they're looking for out. And no surprises that are coming for people looking for.
okay, so,
But we do have all of the technical required information. All the forms are signed,
right,
all those things.
but we do have to make a motion here. Close the meeting before, so. Okay, so would someone like to make a motion?
Motion to close.
All those in favor?
Aye.
Aye. Any opposed? Okay, very good.
So before you guys start, I just want to run through for the record for everyone, because I know we have a lot of old pros in the room and some people that don't participate as much. So now that the hearing's been closed, obviously testimony from applicants or interested parties no longer comes in. The commission can ask questions for clarity purposes. We try to stick to clarity. But kind of most important at all, now that the hearing's been closed, you are required to issue a decision within 21 days. So that's kind of the timeline. So it's not that you guys don't have to vote or draft an order on the fly tonight. I don't think anyone in the room reasonably expects that, but there is now a kind of hard and fast deadline for a decision of some kind to be issued, which is good because that 21 days is before the 1st of July when we may have some commissioner turnover. So, we will be in front of that. So that's kind of what's there. So if you guys want to discuss amongst yourselves what everyone's thinking, getting an idea on what kind of order you guys would like to see or what kind of grouping of orders you guys would like to see to review would be helpful. And then I think for order of conditions discussions, we can probably try to stay on our regular meeting schedule for a bit. And if we need to sneak a special in there to get some extra out, we can. So again, if you guys have questions of legality, I would kind of turn that to George to answer, and he may be able to provide you some guidance there. But that's kind of the procedure we're part of the process that we've entered now.
Well, we could go through all the performance standards. Included. There might be the best start here. I think otherwise, just in general. So.
Do you want to do the local regulations, Mr. Chairman?
Well, what's the feeling of the board here? Local, state?
So local.
I'm thinking local.
I think they're a little more restricted, it sounds like.
Yeah.
And we also have our own, I mean, I just have a comment on the gap lot notion, and that our commission, by looking at, this is bundled, but I don't buy that. I think we still need to look at lots. And what we would have done if we had a other situation where we might have had two CESs surrounding a lot, and somebody came in that had a qualifying lot for a CES, we would have said, well, you have options like a Wilkinson array, which we don't consider a structure. And I don't know why this is any different.
Well, along those lines then, I stand by the original list that I compiled. And so I do have a request to town council. And that is that on lots 79 and 77 have vacant lots owned by the same owners across the street. So under our local bylaw, or even under the state regulation, would you say that they are in imminent danger and so should be protected under either regulation, rather that they can move them to the other side of the street? I'm sorry, that was not phrased very clearly.
Yeah, I think we should, I think we should get a formal opinion on that from me.
Okay.
You know, sooner rather than later, but following tonight's deliberations.
Okay.
I'll check in with Jeff about that to make sure I understand your question exactly, because you said you may not have worded it exactly.
Right. Okay.
And I think that calls for a written opinion.
So I have just a procedural question. Are we done with, did we close the public hearing and we're moving into the order of conditions discussion?
Yes.
We haven't closed the hearing.
Oh.
I thought we voted to close.
We did.
We did close by vote, but we didn't.
Yeah.
We did.
We did.
Sorry,
No, it's okay.
snuck it in.
We're fishing.
Okay. Yeah, trying to find the conditions.
So, George, you'd rather that I spoke to Jeff afterwards to clarify my question?
No, I'd rather know them now.
Okay.
And, if I need any further clarification, I can talk to Jeff before providing something in writing.
All right. So, in my research, number 83 Baxter Road had more than 20% added to it between 1982 and 1991. 79 Baxter Road had more than 20% added to it in 1989, and the owners of 79 also own the lot across the road. 77 Baxter Road had more than 20% added to it in 2006, and the owner of 77 also owns a lot directly across the road. Lot 73 Baxter Road had more than 20% added to it between 1989 and 2012. So
What number was that?
that was number 73. So we actually, according to my calculations, 115, 113, and 109 were built in 1940, 1965, and 1960, respectively. Then from 107, 107A, 107, 105, 101, and 99 are vacant, since 99 has a non-habitable shed from 97, which at one point was claimed to be protectable. 97 and 93 were built in 1954 and 1951. And 91, 87, and 85 are vacant. So if my calculations are correct, there are only 5 houses between 85 and 115 that are entitled to statutory protection as pre-78 buildings. So, and
Yeah, I was looking for the ones in the application, close to our whole set of rates. Well, coastal beaches. Well, I'm just trying to get a general start on this. See if there's any.
So we can kind of skip through them a little bit because
Yeah.
some of them aren't really applicable.
Right.
So obviously for both the beach and the bank, they'd be a little bit different. But
Are we on our local regs right now?
yes, sorry. So under both of those, there's the 378 qualification. So in putting together any order, if you're putting together a positive order for that, you have to have some sort of finding that relates to one qualification is 378, but then also that there are no other alternatives for that. So when you guys have that discussion, that would be, I mean, I think having a discussion amongst yourselves about if you feel that there are other alternatives or not, as part of that deliberation would be something that you would have to do to have a finding against that condition. I think that Ian just asked a question about the 378 that I think
Right,
George
I mean-
addressed, but I think the alternatives question is the kind of meat and potatoes of that. So you would need some sort of finding to address that in any order, and then what conditions would look like to address that if you needed to put extra conditions on to meet that standard.
Right. Well, I mean, you could look about with the pre-78, look at it state and local, whereas the state doesn't seem to be definitely more flexible than we are, and we have a 20% rule. So, I mean, I'm not saying this as I think we all understand that. Reasonable alternatives, honestly, comes up every time we have these discussions. I think we're pretty aware of the alternatives, the reasonable alternatives of potentially moving a structure, although I think the term reasonable has been argued, and the alternatives to the structure has definitely been strongly argued, whether we go back to core or something else that were pre-existing jute bags. I'm not sure there are any other ones there.
I think we have a pretty decent framework in our original order of conditions.
Yeah.
Phase one of this project, but I think our time should be spent in how we are going to enhance the order conditions for this should we go forward.
Mm-hmm.
And I think it's going to come down to trying to project into the future what sort of erosion rates we may be faced with. If this adaptive sand mitigation is going to be appropriate, it's going to work. If it's not going to work, how we're going to hedge against that. Certainly the gap lot question is wrap our heads around, but I think that, at least in my mind, I'm thinking of the gap lots as something where if we were to condition this so that these gap lots had a less robust
Structure.
in front of them, in my opinion, it's just going to start bolting up with it. So,
So, on the one hand, the applicants are saying that NSCAR only takes place in 10 or 15 feet. And then on the other hand, they're talking about the gap lots needing to be protected precisely to avoid any of that, any
well, to Trey's point,
up or down drift damage.
Yeah,
And
to
so it's
Trey's point
contradictory.
that, on a typical lot, you would have the returns starting and ending on that lot.
Mm-hmm.
So the argument that the returns, you get one from one way, one from the other way, taking up a lot of a vacant lot, I don't think that holds water. But I think that there's this proposal requires that this thing be built in its entirety to work, I think.
To work in terms of protecting that stretch of the bluff.
I
Right.
mean, we've gone through the alternatives analysis of the last how many years? Does anybody really think that 4 logs, i.e. Wilkinson array is gonna work out here?
Yeah. I think that since we don't have a time frame on the geotubes, they're not saying this needs to last 3 years, you know, the length of our permit, or 6 years with extensions, not 15 years. The Corps has held up on that beach that's there. You know, with the current installation, a big storm, it has to be rebuilt, but like any bank, that's acting like a natural bluff would. You know, anything's going to need repairs, whether it's the geotubes or core bags. You know, we have an application with a core installation right up the beach, and I think it actually would fit better with the performance standards for beaches. You know, namely wave reflection, nutrient cycling. You know, I think the geotubes have potential to really damage some of our resource areas, especially when we're looking, I guess, at the southerly end where we have dune and the bank really isn't eroding that much at this point. You know, without saying we need this to last 20 years, Corps could be fine. You know, we have our independent reviewer who's, you know, stated that the beach will disappear. So without a time frame, there's no way for us to mitigate for that, or for the applicant to mitigate for that. You know, it needs to be softer, and then you can change in 3 to 6 years when, you know, when you see issues.
I think that the Townsend building, rebuilding the Ward Shoot 4 is going to be incredibly invasive, both on digging into that bank, repairing these things. That is not it's not an easy rebuild in an environment like this.
You get the slumping with the core, so you end up having to rebuild the block.
Well, one is the equivalent of hard armoring, and the other isn't.
I hear you, Ian.
Yeah.
I mean,
I
hear you totally.
Right. But if I may, before I forget, just ask George another question, which is, I don't see how it can be claimed that any of the properties south of Bayberry Lane are in imminent danger. There's still the natural dunes in front of them. And so I'd like a clarification of what imminent danger really is. What?
I think we tried that.
Well,
I don't think there is a term. I think it's one of those legal terms. Well, I mean, we could try to ask them.
It is, so just.
It's one of those legal terms that's sort of up for interpretation.
So to kind of touch on that briefly, that is the final part of that performance standard.
Yeah.
On the local regulations that have it from imminent danger. So any positive order that you issue, one of the findings in there, as you address that standard, would also have to address finding something to be in imminent danger to qualify.
Right.
If that term isn't defined, then you're going to use a regular dictionary definition of imminent danger.
Right.
And if you've got that, you know, you're going to have to look factually in the record. You know, you would apply some type of standard to determine it. Imminent danger, we've proven in the last 3 years there's been 20 feet of erosion per year. If that occurs as it has occurred in the last 3 years, that means that will cause a catastrophic break in the top of the bluff, because that it doesn't have another 20 feet to go, so if it does it that way. You know, so it's that type of analysis. And that did occur, you know, the last time around. There was, you had engineering analysis at the time that the section at issue of Baxter Road was in danger of imminent catastrophic failure because of the rate of erosion out there. So that would be the type of analysis that you want to do. You know, Ian's other questions about the qualification of the lots, I think that probably the best use of your deliberation time would be, looking at performance standards and if they've been met, assuming the lots qualify. And then later on, if you have an opinion that says, you know what, under the bylaw, Ian is correct. In our opinion, you know, lots, whatever they may be, do not qualify under the more restrictive bylaw provision. You know, you can make that decision. Then we deny it because we don't find that these lots qualify under the bylaw. So that's probably the way to do it. But something like imminent danger, unfortunately, is, you know, if I remember from the last time around, it was more dictionary definition based on evidence in the record.
Well, so I guess the question I would have then, we have some lots here that qualify for protection, but many others that don't. But it seems like we're being forced into a thumbs up or thumbs down for the whole thing.
Right.
Instead of saying, well, lots so and so qualify and they can have these GO2s, but these other lots don't qualify and they need to come back in with a permittable, non-structural solution.
Right.
Which I think, you know, if you have a property that does not qualify for protection, you should not expect an easy ride because, oh, but we love our house and, you know, all that stuff. I mean, then maybe they need to face the issues of the core bags or some other less, you know, perhaps robust, but also potentially damaging solution. I mean, I think in some ways these bags are one of the worst solutions out there because, first of all, their depth to height ratio is high. I mean, they take up a huge amount of beach because they're kind of flat. And so they suck up a lot of the, which is public beach, by the way, that they're taking up. And then plus they're hard and they're smooth and they kind of curve. So I think they probably exacerbate reflection, which, you know, we did see in the one big test, you know, a year ago spring, when they really got pounded, we saw in-scour on both ends. And so we know that. And I remember walking that beach and seeing all that scour blanket poking up through, which that really lowered the beach because it's down to the scour blanket that was poking up in all over the beach, if you guys remember that. Yeah. So I don't know. I think these are not, you know, everybody hates revetments, rock revetments, but I don't know. Have we ever denied a rock revetment? I'm trying to think. Or has it just always been? I know we didn't like the
Gabions.
Those gabions, yeah.
Gabions.
That just to remind you, that application that we had for the gabions was withdrawn.
Yeah.
So real quickly, just to answer your question, Ernie, and not to do it, so process-wise for you guys too, is when you're looking at the performance standards, there's absolutely the possibility where you may find that a lot qualifies under the state act that you find doesn't qualify under the local bylaw. And one of the kind of tools in the toolbox for us is the ability to also issue excuse me, two separate orders of conditions, one against the state act and one against the town bylaw. So that's entirely possible that as you conduct that analysis, if you find that, you know, lot A meets the state requirements and lot A doesn't meet the local requirement, that if that ends up causing essentially two permits to be issued, that is certainly well within the right of the commission to do that. We've done that, I don't want to say we've done it a lot, but we've issued split permits out before for different reasons. Sometimes it's how the performance standards apply. Sometimes it relates to which resource areas are applicable as well. Not always, some local resource areas aren't always state resource areas based on size and things. So that's certainly something that's there. As far as looking at the lots differently and applying that, I think I would ask for some clarification to that. But I think, you know, even looking back at the state determination process from the SOC, changes to that project were obviously made on a lot by lot basis based upon what they felt was qualified and was necessary. So I think you would also have the ability to do that as well. But you'd have to have the findings to go with that, where you perform that, much I hate to say it, almost a lot by lot finding set to say, you know, lot A meets the following requirements, doesn't meet the following requirements. Lot B meets the following requirements and doesn't. Some of them may be big grouped together because it may be very clear. But if you're going to find that and make a change or determination based upon differences in those, you just have to have the findings set to go with that, if that made sense to anybody. So.
Yeah, that would be, I mean, that would be my recommended approach.
I was just about to say, because
Lot by lot.
yeah, especially the other side of the street, which
No, that's been removed.
it was removed. The other side wasn't. I wasn't sure if that was the
So, and that would, I think you would have to apply that. So when you look at the lots for the qualification under this performance, you'd obviously be looking to make a couple. One is pre or post 78. And then under the local bylaw, you'd have a substantial improvement finding. And then you'd also have an imminent danger finding to go with that. And then you might also have to have an alternative finding based upon the information provided. So it's kind of a trifecta on that standard that we would need to be due on kind of a lot by lot basis.
Once you did that too, you could also conduct that analysis of, okay, we've gone through this lot by lot, and say I'm not saying predicting your result, but say the result of that is you find that certain lots don't qualify under either performance standard, then you would also want to look at that analysis of, all right, well, is there a compelling reason to allow the project to go forward? Does it sufficiently meet other performance standards so that there's a compelling reason to have an extended project area?
Yeah, I think that you would have to make that as part of that gap lot determination if it didn't qualify, that its location or construction or however it would be is significant to the maintenance of the structure as a whole. So you may have lots that you qualify in as gap lots, and you have to decide if there are other lots that don't qualify, whether they would qualify as gap lots or not. So it's kind of I'm gonna say it's a weird checklist to do for all of them, but I think you'd have to make that determination clear.
Yeah.
Unfortunately, it doesn't allow for a lot of wishy-washiness, so gotta take away the gray.
Also under that, I remember we discussed, Dirk had brought up a point of, way back when, of Sconset Bluff Preservation Fund as an incorporated group. And in the application, we discussed at one point possibly listing each property individually as part of, as opposed to the whole in sort of under the orders. So it wasn't just applied to the corporation, but as to the
So
individually.
I'll see if I can address this a little bit because it's come up a lot with these. So anytime we issue an order of conditions, if it's on a property that was part of the affected project area, so in a lot of cases here, most of the work is taking place on the town-owned parcel. But one of the things they had to provide with the application of this was the property owners that essentially are benefiting from it, or if the upper tier crosses onto their property, or if additional work is crossing onto their property, is they have to provide assent to the application. But then kind of the other side of the coin, there is when an order of conditions issued, as it's a property included in the application, is that order would then also have to be recorded against their property. So it would then run like a regular order on that property. But that's, I don't want to say that's common for all applications, but that's fairly common for all applications if you have multiple parcels involved. You can't get it. And then it also runs with the transfer of the property until a certificate of compliance is issued. So if you purchase a property, you inherit the full effect of the order of any valid order of conditions that's run with that property. So, or any ongoing conditions on a certificate of compliance. So there's not really, you can't sell it and escape. Yes,
Right. I mean, I can only think of one other project on the island that involves so many people.
There are a few.
Presented as a group, so.
Well, I think some of the ones you don't think about that are a little bit more common, that sometimes larger public infrastructure infrastructure projects, so sometimes sewer or stormwater also can affect property owners that go through. I mean, like Duke's Road was one where there are a number of properties where work is taking place kind of in there where they are carrying the full effect of that order on public and private lands, and they've had to sign on to those applications. So some of them are not quite as clear cut, but that is something that that act and the bylaw takes into account and handles pretty well.
So one way I think we could look at this is to pull up our original order, which was a denial for the original project, and go through that, because we considered, I mean, we went through the regs pretty carefully and, you know, looked at each aspect and see if we still agree or disagree with those. You know, that could be a basis of, well, yeah, this is still applicable. I mean, it did get overturned by DEP, but somebody mentioned let DEP write the convoluted. And it was, I mean, I could not believe that thing. It was like, I was looking to see if it was April Fool's Day or not. You know, it was crazy.
And that was also an emergency application
Well, no, it was the notice of intent denied.
that came
And
after.
it sounds like you had two different conversations on the phone, depending on who was talking to. Oh, right?
Right.
So,
Different questions sometimes get different
Yeah.
answers.
Yeah.
Or sometimes the same question worded a little different way gets a little bit of a different answer. So
Oh, well, yeah.
that's why there are 7 of you. You guys get to vote. You get to sort through all of the chaff.
So we can find that original order. on-
Yeah, if it would be helpful, I mean, we can certainly provide you the order. I mean, they're both
It's in here.
kind of part of the record and been provided. So we can provide the order from SC 48 2610, which is the current positive order. I know we've referenced it in. I know Stephen submitted it as part of a submission at one point to go through. If you guys want to review the positive order and the conditions, I know Ben had suggested that going through to see what needed to be perhaps enhanced or revised to improve on that. I mean, that's something
You were
we
pretty thorough on that one.
we try to be as best we can.
Yeah.
I mean, that's certainly something. If you guys want, we can provide them to you guys tonight or tomorrow. I mean, our next regular meeting is Wednesday, so I don't want to jump the gun too crazy and get into it. But then at least give everyone a chance to review those, or we could
Well, they're in the
schedule a yeah.
Yeah, it's
Yeah.
like I have like 10 tabs open trying to get the house distances, the pre-78 qualifications. Like it would be nice to say we're working from these 5 because it's a nightmare to try and find everything. Yeah.
I'd like to see your letter.
Oh, sure.
One second. If you go slow, I'll write it down because I'll make sure I send those out.
Letter of the gap lots and the pre-78 homes. The original order of conditions that you denied. The current order of conditions they denied.
It sort of was basically the overriding, the superseding order of conditions.
Okay.
We're not really addressing the environmental concerns at all.
Well, that's the performance
Yeah.
standards.
And that's the,
I mean,
the big one.
Like when
That's
I'm
another
looking
big one.
at
Sort
the
of
southern
comes
end
out
and we have
right.
beach, dune, and bluff,
Right.
you know, those are a lot of performance standards that they need to meet.
Okay. Although I do believe those are in here.
They were, yeah, we looked at the land under the ocean.
Yeah.
Did they have dune in the first one too?
I don't know if we had.
I don't think there
No,
was.
we
dune.
did not have coastal dune in the
We're
first
not
one.
to deal with that one.
All
No.
right, so that's Emily's point. Let's look at the southern end of this.
It's getting very hard to hear.
Oh.
Especially you all on the right.
Okay.
You all have one mic there.
My job.
Come on, Ben, stop mumbling.
That's my job.
Mumbles Bennett.
Oh, there's a good.
Dude, like Tracy did.
It's okay, I'll take that one. Okay. Yeah, I mean, I think we can, well, the performance standards listed in the orders, but, you know, we can go through and look at them, and kind of list them out.
But
For
to,
the next
to
meeting.
Emily Molin's point, sorry, coastal dune at the southern end of this, right, Emily?
Yeah.
Yeah, that's correct.
So performance standards, as it relates to the whole thing, but particularly as it relates to the southern end, and something that we may have not considered fully.
Mm-hmm.
Well, we didn't have to consider it at all in the original because
Yeah,
they, yeah.
That's good.
I'd like to see the agreement again with the town.
Yeah, I'd also like to get some clarification on what the trigger mechanism was for the, this has been a source of debate, I think. What was triggering the road relocation? I mean, I understand that there's some are thinking that the alternative access was
30 feet.
back to the road as a whole, but in actuality, maybe it was just access to the end. But also there was a trigger mechanism wherein if the project failed or there was a breach, then the road relocation would go into effect in earnest. And I think that there is a chronological confusion about this. What happens?
Right. I think it was a center line down the road distance
So I think we
to
need
the bluff.
full clarity on that.
Okay. And that's in the there are contracts on it.
Yeah.
So, yeah, so you be able to remove any ambiguity on that. There are just probably 3 operative documents to look at. And your issue that you're talking about is just one document in a specific paragraph of that. I can just check. I'm sure Jeff has it, but I can confirm with Jeff what he wants to, remake available to you on that. And I can resend them to Jeff if he doesn't have them.
I'm sure I do.
So, George, if this was denied, this application was denied, would the SOC regarding the original phase 1 still be in force for the town to relocate that section of the road?
That I would have to look at that permit again. I mean, it was a 3-year permit, right? There's a current extension in place. I would have to look at the terms.
So just to jump in on that, because this question comes up a lot. So the SOC was issued, and then subsequent to the SOC, SE 482610 was issued, which replaced the SOC, which was part of being required of the SOC, that if a subsequent filing came in to normalize that it was to take that place. If that makes sense.
I would have to look at that. Your existing order of conditions under both the state and local regulations, what that provides. I know you're under, I think you're under a 1-year extension right now.
Correct.
But I need to review the terms carefully before I answer that. And your question is, what happens to the existing structure?
Right.
In terms of them having to reapply or seek a further extension or
At the time
does it
is
sunset
right.
itself? Or, okay.
One thing that was brought up about the diagram of the tubes being set off from the front of the bank. I do believe that was corrected at one point, wasn't it?
Well, I would say that the plan set that we have that's most current is the one that we just posted.
Yeah. That it's supposed to be more, pushed up onto the bank. Yeah.
Well, it does say for permitting only. So it's not actually. It's not
Right, because that was one of the requirements I remember of the state.
What's that, Andy?
Making sure that the tubes were up as close to the bank as possible to gain as much room and not to have any extension beyond the toe of the bank.
I think especially at the southern end, they don't want to disturb dune and what's currently there. So it really is out pretty far.
Yeah. Well, it's interesting. When we're talking about failure criteria on all these, at what point, I mean, we get into a situation where, especially on the returns, I mean, the structure is fairly robust and has proven itself as a whole in the center, but the ends are its weak points for sure. And it seems there's a certain point where we keep redesigning the ends, and at what point does does the returns not work? It seems like we've been redesigning, and we'll see how the latest redesign goes, but at some point I think we have to have a failure criteria for the returns where it's just not.
Well, I know, I thought we learned that they
Extend
should be soft, and now we're looking
Right,
at
well-
GO2 returns again, despite also an independent reviewer mentioning that it would be better for the returns to be softer. And that's not what we have on our most current plan, submitted last week.
I think we.
I think we all agree we like the soft returns.
Yeah, I think we like the conditions off returns. And I
I
understand.
mean, and I'm looking
extending
at some
them,
of our
but-
performance standards.
Yeah.
and just-
No, the returns have been an issue, and I think we could condition soft returns in our,
I don't
Order.
think we should redesign their project.
well.
Yeah. We've requested some of this stuff
Yeah.
numerous times. We just got a plan last week, so
Right.
that's clearly what they want to settle on, and that's the one we need to assess here. So,
Does everyone sort of feel the same way? Not redesign, okay.
Yeah, that's not,
Okay.
nor is it, it's not a question of approving part of phase two.
No, I know, I was just giving it some flexibility.
It's what it is.
Certain question about certain lots and especially on the ends in the south. Okay. Cool.
To cover it?
do we want to look at any of these performance standards generally today, or are we won't look at it all?
So when we come up with a,
Discuss it.
yeah, could we just
I
sort
need
of
to
break
read
down the
some things, yeah.
individual
Sorry?
ones?
I need to review some things.
Yeah.
Yeah.
So just a question. Do we have a pretty lengthy agenda already on Wednesday?
We always have fairly lengthy
Yeah.
agendas.
Because I just get nervous about stamina and
Yeah, no.
discussing this thing
Since
after
it's starting
a
at
3-hour meeting.
Yeah.
Yeah, it's a pretty typical meeting.
Yeah.
Yeah. Doesn't look
It
horrible.
would be good to have the Ian's questions answered too as well. That's gonna be different, challenging for me by Wednesday night.
So it looks like we should then have a special meeting again to discuss this.
I think we should do
Yeah.
that, yeah.
Yeah.
Continue to either alternate Wednesdays or alternate Mondays or something again.
Mhm.
I know but it is, this is way too time consuming, at least what happened last time, to be trying to shoehorn it into a regular meeting.
Mhm.
Right, I mean, we knew we were gonna go into a special meeting.
Well, how about next Monday? Or is that
That's
too?
all.
That's all.
one of the.
So we can do it next Wednesday probably, because the clock is ticking.
Yeah, next Wednesday.
Wednesday.
This is the 20th.
If we can find a place.
Wednesday I have a conflict, I have a WP project that night.
And I may be off island, I'm hoping to be back by then, but I'm not positive I would be. So I could do
I won't be
Thursday.
here Tuesday.
I can't, I'll be gone early in the week.
Do any day.
Tuesday, Thursday.
Will you be here Tuesday, Ernie?
No,
I won't
I will be gone Monday, Tuesday, and
So
trying to get back on Wednesday. Hopefully we're on an early boat, but you
Well-
never know, you know.
We could shoot for Thursday, the 30th, and then we have a regular hearing back again on June the 5th.
And when do we need to issue this by? What's that date?
The
So,
12th.
12th of June.
10th, July the 10th.
June.
So if we meet on the
That's
30th, then you have the 5th,
41.
and then if worst case scenario, you could go back and have a special on the 10th to issue. That'd be kind of 3 cracks at it. I mean, it probably makes a difference too. If the regular week of Concom, where we have it on the 5th, we could also, in place of field viewings on the 3rd, meet then too. You could do the 3rd, do the 5th, however you guys want to do it.
Might be smart to pencil in June 3rd. I don't know. I worry about trying to do this on
Yeah.
regular meeting
I
night.
agree with that. I think
Yes.
that's too much. All right, where are we landing on here?
May 30th?
Is that the Thursday?
That's the Thursday.
Is that something that you would be comfortable with, George?
Yes. Yeah.
All right, so we'll do May 30th at 4. I'll score us a room somewhere.
4 o'clock.
I'd much rather start at 4 than 5.
Yeah, I'd like to go to the performance standards, but I'd like to have them all sort of organized instead of trying to retaining ones instead of trying to pick and choose right now.
Looks like we may be able to be in here from 4 until 6. Oh, there's a DPW informational session, so that may be possible. But I will, and it looks like the community room may be empty. I'll find us a space.
Okay.
And send that around to everybody. I will aim for this building first, though. But in the meantime, the materials you guys requested, separate of George's opinions, I'll try to get all of you guys tomorrow. So then you'll have that full time to look at it. And then when George finishes his review and opinions, we'll get that to you. So you'll have not a million things to read at once, but that's.
I just got to go through this mountains of information and pick out the pertinent ones. So much.
Well, I would say, I mean, I think if you go back
Repetition, I should
through the
say, yeah.
materials, I think the applicant and the other interested parties did a good job identifying what the applicable performance standards
Right,
are.
and that's
in
what I
there.
was
So
originally looking
there's a
for.
lot of them, like
Right.
under some of them that we're obviously not talking about any peers
Right.
or docs or anything.
No,
You can
I understand.
skip
That's sort of
over
where I
those.
was
So
going to originally go.
You can shorten the list down at least a little bit.
Exactly.
Pretty thorough record of information to read
Did you
through all of
pencil
them.
anything, you have the 30th, you're gonna have that, did you pencil another date in?
I think the dates we were looking at beyond there, George, were part of our kind of our regular sweep. So potentially June the 3rd when we do our regular field viewings that Monday, and then our next regular hearing is June the 5th. So those kind of 2 dates penciled in, and then we have to have it done by the 10th. So I would pencil in the 10th is the drop dead date.
So I'm going to miss June the 5th. So I have a memorial service for a family member. So well,
But
I'm
you're
just,
there for June the 3rd.
You got?
yeah, June 3rd is fine. But
Ian, are you good for the 30th?
yes, I am.
Everybody's good for the
Yeah.
30th?
Good for 30th.
Is everybody good for the 3rd?
Yes.
I am.
And you're not, okay. All right, but you're good for the 5th, George?
I have to be here before the selectmen, for the select board, but the same building. I should be able to do both. Would you start at 4 that day, or?
Yeah.
No, on the 5th is
Would you have that first? Would you have SPPF first?
We could do it before a regular meeting. A regular meeting starts at 5 now, so we could try to do it in front of that, depending on where it is. Some of it may depend on what the 30th looks like. Kind of
Yeah,
what the discussion
I don't
is.
want to inconvenience the board, but if you could start at 4 that day, I could do both. I could handle the.
Yeah, we could always do a special hearing before the regular hearing, and then start the other one a little bit later if necessary. I will facilitate that happen.
I guess 30th, 3rd, and 5th.
Well, as I said, I won't be here the 5th.
Right.
So,
Right, and I think
so
better the 3rd than the 5th, just because the regular meeting I just don't think is smart.
So the only problem is if you want,
I could call in
what you want, but I'm also under the order of the select board.
from a memorial service. I have
On
no
all of
idea.
your deliberations on this.
Yeah.
So I do have a scheduling conflict. I'm sorry to do that.
No.
I'd be much more accommodating.
About, anyone have problems with the 4th?
No, I could do the 4th.
Just to pencil it in as a possibility when looking at the schedule. Like how everyone's laughing at who's playing like useful dates.
I don't mind Tuesday.
I'm pretty flexible.
I mean-
personally, any of these days.
Why don't, could you do the 4th, George?
Yeah.
That Tuesday? Why don't we pencil in the 4th
That
instead?
would be great. Thank you.
And then we'll cover Ian and
And that
George.
would be at 4.
What's that? No, we'll find a space. I know HTC is in that way at that time, so we'll find somewhere. There we go.
I like your thinking.
We like that. Okay.
So we have the 30th and then the 4th, and then the 10th is the last day possible.
Yeah.
So I think maybe after the 30th and the 4th, we can kind of evaluate where we are and see where we're at. But kind of hoping maybe on the 30th, if we get all the information in, we can
That would be nice.
get kind of final instructions out, and then can have the order instructed drafted for the 4th for hopefully it's be nice to do it in one and done for review and questions, but to get through it and then the next one could be there. I think that's reasonable.
And you're
Get
gonna
a
get,
lot of keyboard time in. but-
yeah.
All right, what do we have, Jeff? Give me
The 30th
Yep,
and the 4th.
30th and 4th.
At 4.
At both at 4 o'clock.
Yep.
Room to be determined, right?
But I will send that to everybody involved.
30th at 4. And the 4th. Also at 4 o'clock.
Yes. Both those will be at 4.
And you'll get us those orders.
Yep, I'll
By
get,
Wednesday
so
or
just to
something, or just-
recap my work list.
Email them to us.
Yep, I'll get all the stuff you guys asked
Great.
for compiled. Do you guys prefer it as a one document or separate documents? Because I'll probably post them up to the website too, just as the materials requested.
Can you put it under a separate heading, like?
I'll put order
Here's the
conditioned
stuff you
materials.
Yeah, like
requested
just
or something.
how about-
Another heading.
Yeah, whatever. Right. Yes. I don't know.
Yeah, otherwise
Make it
it's
its own
so hard to
separate
find.
category
Yeah.
entirely.
Yes,
Yeah.
and I will send them to you guys individually as well through email. So you guys
Okay.
The
Not-
only reason I say separate documents
Do we have
is
to
that
close out a
each
meeting?
one is more
Yes.
like easy to navigate.
Yeah. Right now, I mean, we could look this up.
If we
like-
can-
Yeah, can we quiet down?
To the
Yeah,
other
sorry.
room, 'cause we're still finishing up.
Thank you, everybody.
No problem.
Thank you. Ashley, what did you say?
It does. I mean, everyone's talking. It's like melting down in here. I think it's easier to have separate documents, just because some of these documents are so large. If they're added together, then it's like the 500 pages to go through.
Right.
I'll put them somewhere simple and then get them to you individually. That's no problem. Get those to you guys tomorrow.
That'd be good.
What's that?
You got a busy one.
Always. Let me know when it's not.
And if we have any further questions for George, then we should email them to you.
Send those to me. I will forward that to you.
Okay.
Then if there's any confusion on my end, I can sort that out before I send it to George.
Okay.
He's gonna have a busy week too. So, between searching and crossing and this and all the other fun stuff. So.
Okay. So, I think when we get all those, we'll form some better ideas once we have those orders. 'Cause I'm not sure. Is there anything else? Is anybody anything else you can think of at the moment? Okay. So that's about it. So
If someone could make a motion to
well,
continue.
yeah. Oh yeah, we need to continue. Someone make a motion for continuing the discussion.
30th?
34
o'clock somewhere?
Yes.
Okay. All in favor?
Aye.
Aye. Any opposed? Very good. So we'll continue to the 30th.
Motion to
Motion to adjourn.
Anybody-
Second.
All those in favor?
Aye.
Any opposed? No. Okay, we're adjourned. Thank you.
So.
I don't know. I
someone
wasn't there.
copy it?